Somewhere right now, a 22-year-old is signing paperwork for $200,000 in student loans. 4 years of law school, thousands of pages of case readings, professors who speak in riddles on purpose. And at the end of it, they still don't know how to file a basic legal document. Here's the thing nobody tells you: the actual substance of law, the stuff that matters. You can learn the core of it in about 20 minutes. Not the bar exam prep, not the courtroom procedure, but the foundational legal concepts that law students spend 3 years trying to understand we're doing today for free. I'm going to walk you through constitutional law, contracts, torts, criminal law, property law, civil procedure, and a few things your professors would charge extra for. Let's go. Chapter 1. What even is law? Before we get into the specifics, we need to answer the most basic question that somehow law school never directly addresses. What is law? Law is a system of rules that a society creates and enforces to regulate behavior, resolve disputes, and protect rights. That's it. That's the whole thing. But here's where it gets interesting. Law isn't one thing. It's several overlapping systems operating at the same time. You've got constitutional law, the supreme law of the land, the rules about the rules. Everything else has to obey this. You've got statutory law, laws passed by legislatures. Congress passes a bill, the president signs it. Now it's a statute. You've got common law, also called case law or judge-made law. This is where judges interpret existing law and their decisions become precedents that future courts must follow. And you've got regulatory law, rules made by government agencies. The FDA, the SEC, the EPA, they all write rules that have the force of law. Now here's the key concept you need to understand before anything else. The difference between civil law and criminal law. Criminal law is between the government and a person. The state charges you. If convicted, you could go to prison. The standard is beyond a reasonable doubt, a very high bar to meet. Civil law is between two private parties. A person sues another person or a company. The loser pays money, not prison time. The standard is preponderance of the evidence, basically, more likely than not. 51%? This distinction matters for literally everything else we're about to cover. Keep it in your head. Chapter 2. Constitutional law. Constitutional law is the foundation. Every other law in America has to be measured against this document, and if it contradicts it, it's gone. The Constitution does two main things. First, it sets up the structure of government. 3 branches. Legislative makes the law. Executive enforces it. Judicial interprets it. Each one has power to check the others. This is called separation of powers and checks and balances. Second, and this is the part that affects everyday life, it protects individual rights from government overreach, and most of those rights come from the first 10 amendments, the Bill of Rights. Let's do a fast run through the ones that actually come up. The First Amendment. Freedom of speech, religion, press, assembly, and petition. Chapter 2. Constitutional law. Constitutional law is the foundation. Every other law in America has to be measured against this document, and if it contradicts it, it's gone. The Constitution does two main things. First, it sets up the structure of government. 3 branches. Legislative makes the law. Executive enforces it. Judicial interprets it. Each one has power to check the others. This is called separation of powers and checks and balances. Second, and this is the part that affects everyday life, it protects individual rights from government overreach, and most of those rights come from the first 10 amendments, the Bill of Rights. Let's do a fast run through the ones that actually come up. The First Amendment. Freedom of speech, religion, press, assembly, and petition. This is probably the most litigated amendment in American history. Here's what people get wrong about it. The First Amendment only protects you from government censorship. Twitter banned me. My First Amendment writes that's not how this works. A private company can ban you. Your employer can fire you for what you say. The First Amendment says the government cannot silence you. Big difference. The Fourth Amendment. Protection against unreasonable searches and seizures. The government cannot search your home, your car, your phone without a warrant, and a warrant requires probable cause, a real reason to believe you've committed a crime. This is why evidence found in an illegal search gets thrown out of court. That's called the exclusionary rule. The poisonous tree doctrine. The fruit, the evidence is tainted because the tree, how it was found, was rotten. The Fifth Amendment. You cannot be forced to testify against yourself. This is where pleading the fifth comes from. Also, the government cannot take your property without just compensation. That's called the takings clause. The Sixth Amendment. Right to a speedy trial, right to an attorney. If you can't afford one, the government must provide one. This came from the famous case Gideon v. Wainwright in 1963. The 14th Amendment. This one is massive. Equal protection under the law. No state can deny any person equal protection. This amendment was used to end school segregation in Brown v. Board of Education. It's been used to protect voting rights, marriage equality, and much more. Now, here's a concept that ties all of constitutional law together: judicial review. This is the power of courts to review laws passed by Congress and strike them down if they violate the Constitution. It's not actually written in the Constitution. It was established in the 1803 case, Marbury v. Madison. Chief Justice John Marshall essentially said, the Supreme Court gets to decide if laws are constitutional, and that has stood ever since. That's constitutional law, foundation laid, moving on. Chapter 3. Contract Law. Every business deal, every employment agreement, every purchase you make online, contract law is governing it. This is the most practically useful area of law in everyday life. Terms and conditions. 47 pages user clicking I agree without reading. A contract is a legally enforceable agreement between two or more parties. But not every agreement is a contract. For a contract to be valid, it needs 4 elements. Remember these 4. Now, what happens when someone breaks a contract? That's called a breach. And there are 3 main types. A material breach is when someone fails to deliver the core of what was promised. You hired a contractor to build a house. They built a shed. Material breach. The contract is essentially dead and you can sue for everything. A minor breach is when the core delivery happened but something was off. The house was built but the paint color is wrong. You can sue for damages, but the contract itself still stands. An anticipatory breach is when someone tells you in advance they're not going to perform. Hey, I know we have a deal next month, but I'm not doing it. You don't have to wait. You can sue immediately. Contractor disappearing with deposit money. Anticipatory breach has entered the chat. When a contract is breached, courts look at damages. What do you owe the other person? Compensatory damages put the non-breaching party back where they would have been if the contract was performed. Consequential damages, losses that flowed from the breach that were foreseeable. If I'm a photographer and I breach a wedding contract, the couple can sue for the cost of another photographer. They can probably also sue for lost memories and distress, foreseeable consequences. Punitive damages, meant to punish, rarely awarded in contract cases, more common in tort law, which we're getting to. And one more important concept, mitigation. If someone breaches a contract against you, you have a duty to minimize your own losses. You can't just sit there and let damages pile up and then sue for all of it. A court will reduce your recovery if you didn't take reasonable steps to mitigate.
I could have found another job, but I chose to cry court. We're reducing your damages.
That's contract law, the skeleton of every business relationship. Chapter 4. Tort law. Torts. The word sounds weird. It comes from the Latin tortum meaning wrong. And that's exactly what it is. A civil wrong that causes harm to someone. Not this taut image of tart pastry. Tort law is how the civil justice system handles injuries that aren't crimes or are crimes and civil wrongs at the same time. Remember O.J. Simpson? Acquitted criminally, found liable civilly. Same act, different standards of proof. There are 3 main categories of torts. 1. Intentional torts. These happen when someone deliberately does something that causes harm. Battery. intentional, harmful, or offensive contact, punching someone, even offensive touching without consent. Assault, making someone reasonably fear imminent battery. You don't have to touch them. Raising a fist and threatening to hit someone is assault. Assault and battery sounds like a superhero duo. False imprisonment, intentionally confining someone without consent or legal authority. Defamation, making false statements of fact that harm someone's reputation. Two types. Libel is written, slander is spoken. Truth is an absolute defense. You cannot defame someone by telling the truth about them. Important note appears on screen. Truth, absolute defense to defamation. Intentional infliction of emotional distress, conduct so extreme and outrageous, it causes severe emotional harm. Courts set a high bar here. Normal rudeness doesn't qualify. Negligence. This is the biggest category in tort law. Most personal injury cases, car accidents, slip and falls, medical malpractice, are negligence claims. Negligence has 4 elements. All 4 must be proven. Duty. Did the defendant owe the plaintiff a duty of care? Drivers owe a duty to other drivers? Doctors owe a duty to patients? Store owners owe a duty to customers? Breach. Did they fail to meet the standard of care? A reasonable person's standard, not a perfect standard. What would a reasonable person have done in that situation? Causation. Did the breach actually cause the harm? 2 parts. Actual cause. But for the breach, would the harm have occurred? And proximate cause, was the harm a foreseeable result of the breach? Damages. Actual harm occurred. Unlike intentional torts, you can't sue for negligence without proving real damages. 4-box diagram. Duty, forte for, causation, damages. One concept that trips people up: contributory versus comparative negligence. Old rule: contributory negligence. If you were even 1% at fault for your own injury, you got nothing. A harsh rule. Most states have abandoned this. New rule: comparative negligence. Your damages are reduced by your percentage of fault. You were 30% responsible for the car accident. You recover 70% of your damages. Much fairer. I was 1% responsible. Old law. Get out of my courtroom. 3. Strict liability. Some activities are so dangerous that if something goes wrong, you're liable, regardless of how careful you were. Manufacturing defects in products. Abnormally dangerous activities like blasting explosives, keeping wild animals. Guy with pet tiger, sir. This is strict liability territory. You didn't have to be negligent. You didn't have to intend harm. The harm happened. You pay. That's strict liability. Chapter 5. Criminal law. Criminal law is theft crimes. Larceny, taking someone's property without consent with intent to permanently deprive them. Shoplifting, pickpocketing. Robbery, larceny plus force or threat of force. Taking a wallet at gunpoint. More serious, involves a victim who is threatened. Burglary, breaking and entering into a structure with intent to commit a crime inside. You don't have to complete the crime, just entering with that intent is burglary. Burglar stepping through window or their intent has already been established. Criminal defenses. You committed the act, but you have a defense. These are legally recognized reasons why you shouldn't be convicted. Self-defense. You used force to protect yourself from imminent unlawful force. The force must be proportionate. You can't shoot someone for pushing you. Insanity defense. You didn't understand what you were doing was wrong due to mental illness. Rarely successful. Very high bar. And not guilty by reason of insanity often means involuntary commitment, not freedom. Duress. You were forced to commit a crime under threat of imminent serious harm. He said he'd kill my family if I didn't do it. Not available for murder in most jurisdictions. Entrapment. Government induced you to commit a crime you wouldn't have committed otherwise. Police can give you the opportunity to commit a crime. They cannot create the criminal intent. Undercover cop offering drugs, was the intent already there? That's the question. Chapter 6. Property Law. Property law sounds boring. It is slightly boring, but it governs who owns what, and that turns out to matter quite a lot. Property law, everyone visibly falling asleep. There are three types of property: real property, land, and anything permanently attached to it. Your house, a building, trees rooted in the ground. Personal property, everything else that can be moved. Your car, your phone, your furniture. Intellectual property, creations of the mind. Patents, copyrights, trademarks. We'll come back to this. The most important concept in property law is ownership, and specifically, what rights come with it. Property ownership is sometimes described as a bundle of sticks. Each stick represents a right. The right to use the property, the right to exclude others, the right to transfer or sell it, the right to profit from it. Bundle of sticks with each stick labeled. You can own all the sticks, full ownership, or you can split them up. A landlord owns the property but gives a tenant the right to use it. An easement gives someone the right to cross your land. A mortgage gives the bank certain rights until you pay them off. Key property concepts. Adverse possession. If someone openly occupies your land without your permission for a long, continuous period, the exact time varies by state, they can legally claim ownership. Squatter. I've been here 10 years. This is my land now. Law. Actually, yes. This sounds insane, but it exists to encourage land use and resolve disputes where the real owner abandoned property for years. Easements. A right to use someone else's land for a specific purpose. A utility company has an easement to run power lines across your property. Your neighbor might have an easement to use your driveway to reach their garage. Zoning. Government restrictions on how land can be used. Residential zones, commercial zones, industrial zones. This is why you can't open a factory in a suburb. Intellectual property, quick hit. Copyright protects original creative works. Books, music, films, code, automatic upon creation, lasts your lifetime plus 70 years in the US. Trademark protects brand identifiers. Names, logos, slogans. McDonald's golden arches. Apple's logo. Coca-Cola's script. Must be registered and actively used. Patent protects inventions and processes. Must be registered. Lasts 20 years. After that, anyone can use the invention. The key distinction: copyright protects expression, patent protects invention, trademark protects brand identity. Chapter 7. Civil Procedure. Civil procedure is how lawsuits actually work. It's the rules of the game. Not what the law is, but how you fight about what the law is. Civil Procedure Textbook. 1,400 pages to get to the actual court part. Fast version. Step 1. Filing the complaint. The plaintiff, the person suing, files a document stating what happened and what they want. This is called the complaint or petition. Step 2. Service of process. The defendant must be formally notified they're being sued. You can't sue someone without telling them. Step 3. The answer. The defendant responds. Admit some things, deny others. Raise defenses. Step 4. Discovery. Both sides exchange information. Documents, emails, depositions, sworn out-of-court testimony. This is where cases are really won or lost. Most evidence comes out in discovery. Lawyers drowning in document boxes during discovery? This is fine. Step 5. Motions. Before trial, lawyers file motions, asking the judge to rule on things. Motion to dismiss. This case has no legal basis. Motion for summary judgment. There's no real dispute about the facts. Just rule now. Step 6. Trial. If it gets here, and most cases settle before this point, you have opening statements, witnesses, cross-examination, closing arguments, and a verdict. Step 7. Appeal. The losing party can appeal, but appeals courts don't retry the case. They review whether the trial was conducted correctly. New evidence is almost never introduced on appeal. Flowchart, complaint, service, answer, discovery, motions, trial, appeal. One critical concept, jurisdiction. Before any of this starts, the court must have the power to hear the case. Subject matter, jurisdiction. The court must have authority over this type of case. Federal courts hear federal law cases and cases between citizens of different states over $75,000. Personal jurisdiction. The court must have authority over the person being sued. You can't be sued in a state you have no connection to. I'll sue you in Antarctica, no jurisdiction, bro. Chapter 8. What law school doesn't teach you. Real talk for 60 seconds. Because law school famously does not teach future lawyers how to actually practice law. Law school graduate on day 1 at a firm, poor fee one, paralyzed. They teach you to think like a lawyer, to argue both sides, to find issues in a set of facts. This is the famous Socratic method. Professors call on you randomly and ask impossible questions to force you to reason out loud.
What they don't teach you.
How to write a real contract, how to file papers at a courthouse, how to talk to a client, how to negotiate a settlement, how to run a business. And law is a business. 3 years of law school, can you draft a simple lease? Nervous sweating. This is changing slowly. But for decades, law school has been deeply theoretical, and the bar exam tests you on even more theory before you're allowed to actually help anyone. The practical skills? Most lawyers learn those on the job from senior partners by doing. One more thing, legal ethics. Every lawyer takes professional responsibility seriously or is supposed to. The duty of competence. The duty of confidentiality, attorney-client privilege, means your lawyer literally cannot tell anyone what you tell them in the course of representation. The duty of loyalty, no conflicts of interest.
Representing both sides in the same dispute is forbidden.
Attorney-client privilege. So I can tell you anything? Within certain limits, yes? Attorney-client privilege is one of the strongest protections in law. It survives even after death in most cases. It's why you should always speak to a lawyer before making decisions in legal matters. That conversation is protected. And that is the entire foundation of American law. Constitutional law, the rules about the rules. Contract law, every agreement you make. Tort law, when someone wrongs you in civil court. Criminal law, when the state comes after you. Property law, who owns what? Civil procedure, how you fight about it. You now have a stronger grasp of legal fundamentals than most people who have never set foot in a law school, and you paid exactly $0 for it. Next video, I'm doing the entire psychology degree. Freud, Maslow, Pavlov, cognitive biases, social psychology experiments. The stuff that explains why humans are the way we are. In 20 minutes. No textbook required. Subscribe. Because education shouldn't cost $200,000.